Welcome and thank you for joining San Diego Real Estate Talk with Rosita. I'm Rosita Perez, your host, realtor, and self-discovery coach. I get to help people find their way home, whether home is a physical home or if home is discovering the core of who you are. As a San Diego realtor, I've witnessed the profound impact homes can have on loved ones, especially after the homeowner passes. So let's talk about that for a minute. So when homeowners have passed away, there are two options that one of these options need to be added in order to transfer your home into a legacy that you want to leave behind for your loved ones. So back in February, I recorded a podcast called Crafting Your Everlasting Legacy, Living Trust versus Transfer on Death Deed 101. It gives an overview of both options. And then on March 1st, I had attorney Yvette Cuyate join me to discuss living trust in depth. You can watch both recordings on my YouTube channel at Moving Forward Life Coach Realtor. So today, my guest and I will be talking about the second option, transfer on death deed. I have joining me Christy Cimino. She's the Vice President of Sales with Equity Title. Christy will share information on transfer on death deed, commonly referred to as TODD deed. She'll share the benefits and some other stuff we'll get into. So let me get Christy on board. Welcome, Christy. Thank you so much for being here and giving us this information. I really appreciate it.
Oh, my pleasure. My pleasure. Always nice to talk with Rosita.
And if you're looking for anything to do with your title, she is the woman to go to. There is so much to go over, and this is just going to be a quick overview because we can direct them to who to go to for more questions, but I wanted to give the audience a little bit more information. So let's go ahead and get started.
Sounds good.
All right, so let's talk about what does the TOD deed do?
The transfer upon death deed, just to give you a little background, it became effective in January of 2016. It is actually California Assembly Bill 139. So it was voted and it modifies portions of the family code. Family code is family law and also has things about probate. So it added a new section to the probate code, which was section 5600. The probate courts were getting so inundated with having to do probate, basically because people did not have their property in a trust. And then they have to go to probate and you hire attorneys and it could be 30, 60, 90 days or even longer. It could be $20,000, $30,000, $40,000 depending upon the size of the estate. So it really didn't benefit either party. So they created this transfer upon death deed. What that did was it alleviated the process of probate, predicated on that they filled out and filed this transfer upon death deed form prior to their death. In a nutshell, that's how it kind of came created. They were extending it just about every year, kind of testing the waters to see if people were actually doing it. It caught on about a year or two later. So now they have extended it indefinitely until January 1st of 2032. I would imagine this is gaining more speed, that they might extend it even further because it does benefit a lot of people.
It makes sense. This is an alternative.
Correct. Yeah. If you've got somebody that doesn't have a lot of assets or their assets are stocks, you normally would name a beneficiary in your financial planning and your stock account. So then you're just left with your house. So yeah, are you going to spend $3,500, $4,000 just to put your home in a trust? Most people, especially if they're seniors, that's not in their budget. So this is a great option for them as well.
And so I get questions like, can I use this deed to transfer business property?
Unfortunately, no. This was created for parcels units, that's single family homes, that's condominiums. It can be duplexes, 2 to 4 units. It could also be acres of land, up to 40 acres of land, but you have to have a home, a residence on that land. So that's all that qualifies for the TODD. And that really is the bulk of, the business, commercial property and businesses, they have their own loopholes and things to do, because then you're getting into corporations and LLCs. The average person, the homeowner, this is basically meant for them.
If it's joint tenancy,
you have to be the last surviving spouse. So if you're joint tenants, that's one thing, or your tenants in common. Most married couples are community property with right of survivorship. So let's just say, the husband passes away, his 50% is already going to the wife and or the spouse. But her 50% or the 100%, because she gains, where is that going? That's a situation where she would put that property into a TODD. If you're a single person and you don't have the money for a trust, or, when you're young and you're single, you think, oh, nothing's going to happen to me. Well, a lot of times it does. And then the family's left with trying to dig all this up and do everything with it. So even if you're single, you can do a transfer upon death deed. The last surviving spouse can do a transfer upon death deed. If you're holding it as tenants in common, you can take your half and put it into a TODD, but that doesn't automatically mean that the other half of the person automatically gets that TODD. They would have to do it themselves as well.
Okay, let's backtrack on that for a second. So there's like a mother and son, and it's joint tenancy, right? Mm-hmm. The mom passes away, and she has her TOD deed given to the sister.
Correct.
So now the sister and the son own the property.
Right.
Okay. I just want to make sure I understood that.
Right. They can do it themselves, or because it's joint tenants. Well, normally in joint tenants, you would name that. But yeah, it's whatever your interest amount is.
Okay. And then both joint tenants have to create their own TOD.
Correct.
Okay. So Christy, can a homeowner revoke the TOD deed if they change their mind?
Yes, there's a couple of ways that the transfer upon death deed can be revoked. If you file a transfer upon death deed, but then later on you go and create a whole trust, that automatically voids the TODD. If you, let's say you create a will, the wills do not take precedence over TD. That's a separate thing. So a will is not a transfer upon death deed. If you sell or give away the property or transfer it into trust before the death, and you have already recorded your TODD, that will revoke it as well. And they have a special form for filing for it, and then they have another special form for revoking it.
Okay, and so it does have to be revoked.
Correct. If you're going to change that, if you decide, oh, wait a minute, no, I don't want to do that. Or if you're going to change beneficiaries in the form, you can name beneficiaries. So you have 100% interest. So you can give 50% to John and Mary. You can give 25% to Bill and Tom. You can name out the percentage of that you want your beneficiaries basically to have. If you want to switch them out, then you need to file another form, obviously, because you're switching out the beneficiaries.
So this is another question that I get. Let's say a couple wants to name their children as beneficiaries, but they are not 18 yet.
That is going to be an issue because you have to be, 18 and older in the state of California to sell property. So I suppose if they weren't going to sell his property and they were going to wait till they became of age, then they could do something with it then.
So I think we've already discussed this, but can a homeowner revoke a TOD deed by creating a new document that disposes of the property?
Yes, you can do that. Yeah. Any modifications to the original TODD would have to be refiled.
What are the benefits of having this TOD deed?
Well, the biggest benefit is you're avoiding probate. You're avoiding 30, 60, 90 days. If they're trying to sell it, you're avoiding a lot of money that's going to come out of the beneficiary's estate. That's basically why the TODD was recorded, if they meet all that criteria. Now, one thing, the TDD has no effect until you die, obviously. You can revoke it at any time. But due to Proposition 19, which became in effect about 4 or 5 years ago, the TODD can be used to pass real estate to children if the property is worth less than $1 million. and the children intend to make the property their primary residence. So that's a big caveat. Prop 19 came into play, and it basically did away with the Prop 6090. Prop 6090 was you could only transfer your property tax basis in only 11 counties in California. And then when you went to buy, it had to be equal or less to the replacement property or existing property. They did away with that and created Prop 19. So now you can and you had to be 55 and older, and it was only a one-time thing, the original Prop 6090. Prop 19 said, okay, we're going to let you transfer up to 3 times if you're 55 and older. We're going to do away with the 11 counties that we previously did, and now you can transfer within the whole state of California. And you didn't have to buy equal or less as to what you sold. So everybody was like, wow, that's a win-win. Well, the caveat to that, in the old 6090, if you passed it on, the property tax, they didn't have to live in the property. Now the Prop 19 says, okay, if you're going to take that low transfer tax base, siblings, you have to live into the property for 2 out of the last 5 years. So that kind of prevented a lot of siblings from just selling grandma's house and taking the money and running. But to still save that tax base, it may be worth to just put somebody in there for a couple of years and then call it a day.
Yeah, that makes sense. For homeowners that name a beneficiary, what does the beneficiary have to do when the homeowner dies?
Well, once they fill out this form, they will take it to the county recorder's office in San Diego. There's one up in Oceanside Vista. There's one in Santee. There's one in El Cajon. And then you have the main one down on Pacific Highway. They take that form in there. They file it, basically. It tags with the records. And then we at the title companies, if they're selling the property upon the death, we will note that in what we call a preliminary title report. So that gets filed under the assessor's parcel number. And then we will see that when we do the preliminary title report, and it will say on there, this property has a filed TODD. And then we will pull a copy of that, see who the beneficiaries are, and then escrow would notify them from there. A lot of people say, well, should I let my beneficiaries know, that they're getting, a portion of my home? Yeah, it's up to the individuals. Secrecies can create a lot of tension within families that are already stressed at that point to begin with. But it also will prevent people from putting in fraudulent claims and saying, yeah, I'm Susie, I'm the beneficiary. And then the real Susie is like, well, no, really, you're not, because I'm supposed to be on that and I'm the real Susie. So, you can play that either way.
Yeah. And on the form, I'm looking at the form. Is it just one beneficiary that they can name?
No, you can name as many as you want. You have 100% interest. So how you want to divvy that up is how you're going to divvy it up. Okay. So yeah, you can have as many people on there as you want, but you have to make sure that how you're breaking it out equals that 100%.
Okay. Now for this form, you can contact me for the form, and I can also give you the APN number and the other information that you will need. And then you would take it to the notary to get notarized, of course, and then take it down to be filed. And that, correct, depending what county you're in, I think the fees kind of vary, but I don't think it's over $100.
No, it's not even that. It's not even that. They go by first page. Document is $15. Second page is, you're not really going to have a second page. It's very, very inexpensive to basically protect your assets and avoid paying heavily fees for, an actual full-on trust. You can still have the TODD in a will. I leave my car, my jewelry, that kind of stuff goes into a will. That's not going to be what you're going to put in a transfer upon death deed. That is strictly for real estate only.
And it does not expire unless you replace it with the trust, or you
fill out a new one and you're naming other beneficiaries. Yeah. Or you just want to revoke it altogether, right. So you can rescind without, the other things as well. One thing that they did do last year was they just only required one witness in the form to be filled out. Now they have added, they want 2 different witnesses, and they don't want, and you really should not be one of the beneficiaries, because obviously that's a conflict of interest, nor should you be related. So they want two distant, it could be a neighbor and it could be a coworker. They would like to see that, but you are going to have to bring in two witnesses to the notary as well. And they all have to be present, obviously, at the time that you're notarizing the form.
Such great information,
Yeah.
Christy, and such a great option because nowadays everything is so expensive. So at a minimum, this transfer on death deed is definitely a plus to add to protecting your home.
Correct. Yeah, but I think it was a great, and there are other states that have followed into this transfer upon death deed. I would Google, the state that you may be moving into, or maybe you've got your grandparents living in Arizona. They're not aware of this. You can easily find out if that state has a transfer upon death deed. In the beginning, there weren't that many, but more states have caught on. They might have some more requirements or less requirements, obviously left up to the state. But yeah, they should definitely check.
Right. And I know we talked about this earlier, but if a homeowner needs specific information on their situation, they should probably contact the tax assessors and or their CPA.
Yeah, your financial planner or your accountant would be best as far as getting into the ins and outs of it. Rosita and I can only just basically state what it does. We can't give legal advice. So you always want to check that on how things are going to be, how they've been taking their deductions, or especially if it's absentee owned property. So always best to check with your CPA if it works for you or doesn't work for you, but at least you have those options.
Exactly. So I just want to let you all know that we highly recommend protecting your home with either a living trust or a transfer on death deed, depending on what your situation is. And please know that if neither of these are chosen, the state is going to end up managing your assets through a process called probate. That was what Christy was talking about earlier. And that is basically when you don't have a living trust or a transfer on death deed, the homeowner's assets are managed by our state, and hearings are held in the probate department of the Superior Court. As Christy mentioned earlier, the attorney fees could be anywhere between 8 to 10%, could be higher depending on the value of your home. And if you need to sell your property, then that's going to incur realtor fees, closing costs, which can be 1.25%. Of course, other additional fees, it'll take several months to several years to handle because sometimes they're complex. Thank you so much, Christy. This was such a great wealth of information. Okay, Christy, that was a quick overview of the TODD and probate. I hope this information is value add for you all, and more importantly, motivates you to protect your assets. I encourage you to gather your information and determine what your needs and goals are, and then schedule an appointment with your CPA, your estate planning attorney, can help you get to an answer that you need for your specific situation. So, Christy, we talked about who to contact. That's the CPA or the tax assessor's office for further information. And I just want to thank you so much, Christy, for joining my podcast and sharing your expertise on this topic.
Of course, of course. And like I said, Rosita, I did give her the more informational sheets, and she also has the forms to submit. So reach out to Rosita. I've been working with her for eons. And she's a great realtor. She's got a great attention to detail, and she's always there for her clients. And I personally know how hard she works. So
Christy is right there beside me. She is the one who calls me and says, "It's recorded. It's closed. They own the property now."
It takes a village, real estate transactions, title, escrow, mortgage. It's a very complicated process. And a lot of times the buyer and sellers don't see the behind the scenes situation and really what goes on. And there's a lot of moving parts. So it really does take a tight team with knowledge to make your transactions close.
Thank you so much for joining us today, Christy. I appreciate you.
My pleasure.
When you all have questions on real estate, please contact me at 619-665-9086. You can go to my website, search for properties, get other real estate information. My website is rositasellshomestoday.com. And please go to my YouTube channel, subscribe, and listen to previous recordings. My channel is at Moving Forward Life Coach Realtor. Thank you for listening to San Diego Real Estate Talk with Rosita, and we will see you next time. Bye.